Good morning. Welcome to the May 2021 open meeting of the Federal Communications Commission, where we just announced that one weekend we have enrolled more than 1 million households in our new emergency broadband benefit program. And that includes households from all 50 states, DC, Puerto Rico, the Virgin Islands, and American Samoa. It's good news for the largest ever broadband affordability program in the United States. And I want to thank my colleagues for their historic work on this. Now, Madam Secretary, would you please introduce our agenda this morning?
Thank you, Madam Chairwoman. Good morning to you and good morning, Commissioners. For today's meeting, you will hear 6 items for your consideration. First, you will consider a 3rd report and order on reconsideration, and 5th notice of proposed rulemaking that, among other actions, will lower interstate rates and charges for the vast majority of incarcerated people, limit international rates for the first time, and seek comment on further reforms to the Commission's calling services rules, including for incarcerated people with disabilities. Second, you will consider a notice of proposed rulemaking in order to set telecommunications relay services, TRS, fund compensation rates for video relay service, VRS. Third, you will consider a further notice of proposed rulemaking to fight illegal robocalls by proposing to accelerate the date by which small voice service providers that originate an especially large amount of call traffic must implement the Stir Shaken Caller ID authentication framework. Fourth, you will consider an order on reconsideration to relieve certain affiliates of merging companies that receive model-based and rate of return universal service support from a mixed support merger condition cap. Fifth, you will consider an enforcement action. And sixth, you will consider an enforcement action. This is your agenda for today. The first item is entitled Rates for Interstate Inmate Calling Services, and will be presented by the Wireline Competition Bureau, and Chris Monteith, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Ms. Monteith, please proceed.
Good morning, Madam Chairwoman and Commissioners. The Wireline Competition Bureau is pleased to present for your consideration a 3rd report and order on reconsideration, and 5th further notice of proposed rulemaking regarding inmate calling services, or ICS. I would like to thank the entire Bureau team for their hard work on this item, as well as our colleagues in the Consumer and Governmental Affairs Bureau, the Offices of Economics and Analytics, and General Counsel, with whom we collaborated extensively. Eric Raven Hansen, Attorney Advisor in the Bureau's Competition Policy Division, in the Pricing Policy Division, will present the 3rd report and order, and Peter Bean, also an Attorney Advisor in the Pricing Policy Division, will present the order on reconsideration and the 5th further notice of proposed rulemaking. Eric, floor is yours.
Good morning, Madam Chairwoman and Commissioners. Last August, the Commission unanimously adopted a 4th further notice of proposed rulemaking to comprehensively reform the rates and charges incarcerated people and their loved ones pay to keep in touch by telephone. The 3rd report and order before you, if adopted, will substantially implement the Commission's proposals in that August 2020 further notice, providing financial relief for the vast majority of incarcerated people and their families. If adopted, the report and order would substantially reduce the interim rate caps for interstate inmate calling services from all prisons and larger jails with average daily populations of 1,000 or more incarcerated people from 21 cents per minute for debit and prepaid calls and 25 cents per minute for collect calls to new uniform interim interstate caps of 12 cents per minute for prisons and 14 cents per minute for larger jails. The order would maintain the current interim interstate rate cap of 21 cents for debit and prepaid calls at jails with less than 1,000 incarcerated people because of insufficient record evidence to determine providers' costs of serving those facilities at this time, but would eliminate separate higher collect call rate resulting in uniform interstate rate caps for all types of interstate calls in each facility. The order would also reform the treatment of site commission payments, where specific site commission payments are mandated by state statute or laws or regulations. Providers would be allowed to pass those payments through to consumers on an interim basis, up to a total rate of no higher than 20 cents. Where site commission payments result from negotiated contractual obligations between providers and correctional officials, providers would be permitted to recover from consumers no more than an additional 2 cents per minute, resulting in maximum total interstate rate caps of 14 cents per minute for prisons and 16 cents per minute for larger jails, where these negotiated payments are made, as we proposed in the 2020 ICS notice. The order would also cap, for the first time, international calling rates for all incarcerated people at all facilities. It would reform the ancillary service charge caps for third-party financial transaction fees, including those related to calls that are billed on a per-call basis. And it would adopt a new mandatory data collection to obtain more uniform cost data based on a consistent allocation methodology to determine just and reasonable permanent cost-based rate caps for facilities of all sizes. I will now turn things over to my esteemed colleague, Peter Dean, who will present the order on reconsideration and the fifth further notice of proposed rulemaking. Thanks.
Thank you, Eric. Good morning, Madam Chairwoman and Commissioners. The order on reconsideration, if adopted, would deny a petition filed by Global Tellink Corporation seeking reconsideration of a single sentence from the 2020 ICS order on remand, in which the Commission reminded providers that the jurisdictional nature of a call, that is, whether it is interstate or intrastate, depends on the physical location of the endpoints of the call and not on whether the area code or NXX prefix of the telephone number associated with the account are associated with a particular state. The order on reconsideration would reiterate that the end-to-end analysis has been and remains the generally applicable test for all telecommunications carriers in determining the jurisdiction of their calls, and would reaffirm the Commission's continued reliance on the traditional end-to-end analysis for the purpose of determining the appropriate rate caps applicable to calls by consumers of inmate calling services. The fifth further notice of proposed rulemaking, if adopted, would seek comment on a variety of topics designed to permit the Commission to adopt further reforms to benefit incarcerated people, including those with disabilities. Specifically, the fifth further notice proposes to amend the Commission's rules to require calling service providers to provide access to all forms of telecommunications relay services, including internet-based services, to facilitate greater accessibility for incarcerated people with hearing and speech disabilities. The further notice would seek comment on how best to set permanent rate caps for interstate and international inmate calling services at facilities of all sizes, reevaluate the treatment of site commission payments to ensure that permanent interstate rate caps are just and reasonable, and curtail potentially abusive practices related to ancillary service charges, among other reform issues. The Bureau recommends adoption of the item and requests editorial privileges. Thank you.
Thank you. We will now hear comments from the bench, and we'll begin with Commissioner Carr.
Thank you. I recently heard from several families who had experienced firsthand the difficulties of maintaining contact with their incarcerated loved ones. I also heard from formerly incarcerated individuals who underscored the decline in mental and emotional health that can result from a lack of external communications. Beyond that, studies have repeatedly shown that increased communication between incarcerated people and their families, friends, and other outside resources helps reduce recidivism rates. And the COVID-19 pandemic put even greater emphasis on inmate calling services as in-person visits have been severely limited. The FCC has a critical role in promoting just and reasonable rates for inmate calling services. So I'm pleased that we're acting on our 2020 proposal to make these calling services more affordable. I'm also pleased that we're seeking comment on the availability of functionally equivalent communication services for incarcerated people with hearing or speech loss. It's critically important that these individuals have equal and affordable access to communication services that will allow them to interact with family, friends, and other important resources such as attorneys and medical professionals. As we move forward in this proceeding, I'm also interested in additional comment on the role that site commissions play in the rates for inmate calling services and whether the commission can and should do more to address those charges, which can add to the cost of providing services inside correctional facilities. I want to recognize the staff of the Wireline Competition Bureau. They have worked very, very hard on these important issues. You have my thanks, and the item has my support. Thanks.
Thank you, Commissioner Carr. Now we'll hear from Commissioner Starks.
Thank you, Madam Chairwoman. One of the hard life lessons that the COVID-19 pandemic has taught us is how crucial it is to be able to connect with loved ones both near and far, even when you're unable to see them in person. That reality has been felt deeply by the more than 2 million incarcerated individuals throughout the United States, and as prisons and jails across this nation temporarily ceased visitation to help stop the spread of the novel coronavirus, incarcerated people became solely dependent on inmate calling services to remain connected to those outside the walls of the correctional facilities. And for many incarcerated individuals, the price to connect with their loved ones, no matter how frequent or infrequent, is far too costly. But the price to remain unconnected is just as costly because there is increased risk of recidivism, deteriorating mental health, and the lost connections with children in particular, which impact incarcerated individuals, their families, and our society as a whole. And so as we continue to hear resounding calls for equity and justice for our most marginalized communities, the order before us today serves as a reminder that our longstanding fight for prison phone justice continues. The lowering of interstate rate caps at prisons and large jails is a step in the right direction. These interstate rate caps and additional reforms are being set on an interim basis. And because of that, I'm hopeful that there will be opportunities to further meet the Commission's obligation of ensuring that there are just and reasonable charges made to incarcerated individuals and their loved ones who are using ICS services to remain connected. It is imperative that we obtain accurate data and clearly establish the costs of running a correctional facility versus the true costs of running a communication service. And I was pleased to see the acting chair's office accept my changes to ensure that international call termination charges are transparent to consumers. Transparency is an important part of ensuring incarcerated individuals and their families and friends are charged those reasonable rates, including during international calls. And as noted in this order, there are additional challenges that incarcerated individuals with disabilities face in their quest to remain connected, as they are often subject to what disability rights advocates call a prison within a prison. And with today's action, we reaffirm ICS providers' obligations to ensure services and equipment are accessible and usable by incarcerated people with disabilities. I'm also pleased to see the robust further notice that seeks comment on the provisions of functionally equivalent communication services to incarcerated people with hearing and speech disabilities. And let me close. We are here today, as we have been with many moments in history concerning justice in this country, because of the path paved by Black women, including Martha Wright and former FCC Commissioner Mignon Clyburn, who have led the way in this long fight against exorbitant ICS rates. And so we're here today because also of the efforts of prison phone justice advocates and disability right advocates who played such an integral role in this process and will continue to work with us on permanent relief solutions. Thank you, of course, to the Commission staff for your very hard work on this order and continuing to impact the lives of incarcerated individuals and their loved ones.
Thank you, Commissioner Starks. Commissioner Simon.
Thank you very much. This item, of course, enjoys my support. I am I concur with the remarks about its importance expressed by my fellow commissioners. And although everyone has recognized the hard work of the staff on this one, I would like to particularly emphasize this because this is a dense, thorny matter that's required extremely extensive treatment by the staff, particularly given the complex legal history and regulatory history of this issue. So in bringing any kind of important change over the line, I think the staff has had to work particularly hard on this item, and I'd especially like to note that.
Thank you. With today's action, the FCC takes a step forward to address the high cost that incarcerated people and their families pay for phone service. Let me be clear. This is not the last action we will take because there is more that needs to be done. I know the road to phone justice has been too hard and taken too long. But I also believe every step counts because this is not just an issue of markets and rates. It is a broader issue of social justice. Consider that across the country, 2.7 million children have at least one parent who is incarcerated. In many cases, those who are incarcerated are separated from their families by hundreds of miles, and their kin may not have the time and means to make regular visits. Phone calls are the only way these families can stay connected. But when a single call can cost as much as most of us pay for an unlimited monthly plan, the financial burden of staying in touch can be too much to bear. This harms the families and children of the incarcerated. But it goes beyond that. It harms all of us because we know that regular contact with family members produces recidivism. Now consider the pandemic. It has touched every corner of American life, but the incarcerated have been hit especially hard. According to one analysis, nearly 400,000 have been sickened by this cruel virus. Nearly 2,700 have died. That's not all. The dangers of COVID-19 have led many prisons and jails to stop in-person visitation. That makes simple phone calls more important than ever. So today we provide relief to incarcerated people and their families. Recognizing the exigent circumstances caused by the pandemic, we lower interim interstate rates for prisons and the largest jails. That means that interstate rates will fall by more than a third for the vast majority of those who are incarcerated. For the first time ever, we cap international rates. No longer will providers be able to charge an immigrant $25 to make a 3-minute call to his or her family abroad. We eliminate the outdated surcharge for collect calls, and we make it clear that providers must give incarcerated people with disabilities functionally equivalent communication services. But again, this is only a step forward. We include a rulemaking so we can clear the way for further reforms. We will collect better data for all facilities. We will take a hard look at whether site commissions that providers pay prisons or jails should be permitted at all. We will investigate whether the current ancillary service charges for placing a single call or for using a credit card are just and reasonable as required by the Communications Act. And we will press harder on ensuring functionally equivalent access for incarcerated people with disabilities. There's more we can do. Because as a matter of social justice, we are not yet where we need to be. But we wouldn't even be here now without two women who got this effort started and put us on the road we are on today. There is Martha Wright. It was nearly 2 decades ago that Martha Wright petitioned this agency to rein in the unconscionably high rates paid to call incarcerated people. She did this because it was personal. She was a grandmother who wanted to keep in touch with her grandson. She passed away several years ago, but her legacy lives on. There is also my former colleague and former acting chairwoman, Mignon Clyburn. When others were presented with the petition from Martha Wright, they looked away. It was uncomfortable. It was a cause too hard, a proceeding too rough, and the legal issues too thorny. But she saw a wrong that we needed to make right. She called on this agency to act, and her efforts and moral compass led us to where we are right now. So we will continue to press on in their honor and on behalf of the millions of families who deserve the ability to simply keep in touch with their loved ones who are incarcerated. We also praise those in Congress who have long championed legislation to fix this problem. That includes Senator Tammy Duckworth and Congressman Bobby Rush, who deserve special note for their efforts to extend our jurisdiction to cover the high cost of intrastate calls. Finally, I want to thank the extraordinary professional staff of this agency, many of whom have worked for years and years to address these matters. They include Irina Asakov, Susan Barr, Allison Baker, Larry Barnes, Peter Bean, Michelle Burla, Kimberly Bradley, Justin Falb, Amy Goodman, William Kehoe, Minsu Kim, Albert Lewis, Rhonda Lean, Chris Monteith, Catherine Moorhead, Terry Natoli, Eric Raven Hansen, Sherry Ross, Marvin Sachs, Simon Soleimani, and Gil Strobel of the Wireline Competition Bureau. Bob Aldrich, Diane Burstein, Elliot Greenwald, Deborah Patkin, and Patrick Weber of the Consumer and Governmental Affairs Bureau. Peter Alexander, Connor Altman, Mark Azek, Tavi Carrere, Paula Check, Keaton Cobbles, Stacey Jordan, Susan Lee, Stephen Kaufman, Ying Key, Eugene Kislev, Dick Kwiatkowski, Julia McHenry, Amy Nathan, Eric Ralph, Daniel Scheinman, Emily Talaga, Shane Taylor, Mark Wachula, and Jeff Waldo of the Office of Economics and Analytics, and Sarah Citron, Michelle Ellison, Valerie Hill, Jake Lewis, Marcus Mayer, Rick Mallon, Linda Oliver, Joel Rabinovitz, and Bill Richardson of the Office of General Counsel. We will now proceed to a vote on the item. Commissioner Carr.
Approve.
Commissioner Starks.
Approve.
Commissioner Symington.
Approved.
And the chair votes aye. The item is adopted with editorial privileges as requested. Madam Secretary, please announce the next item on today's agenda.
Madam Chairwoman, Commissioners, the second item today is entitled Telecommunications Relay Services and Speech-to-Speech Services for Individuals with Hearing and Speech Disabilities, Structure and Practices of the Video Relay Service Program. And it will be presented by the Consumer and Governmental Affairs Bureau. Patrick Weber, Chief of the Bureau, will give the introduction.
Thank you, Madam Secretary. Mr. Weber, please proceed with introducing item number 2 on today's agenda.
Thank you, and good morning, Madam Chairwoman and Commissioners. Today, the Consumer and Governmental Affairs Bureau presents to you a notice of proposed rulemaking and order on video relay service, or VRS. This service, which is supported by the Telecommunications Relay Services Fund, enables people with hearing or speech disabilities who use sign language to make telephone calls over broadband with a video phone. The item seeks comment on TRS fund compensation updates for providers of VRS and extends the current VRS compensation plan in the interim. I would like to thank CGV staff for their hard work on this item. I would also like to thank the Office of Economics and Analytics, Office of the General Counsel, Office of the Managing Director, and the Office of Communications Business Opportunities for their contributions to this item. Michael Scott, an attorney advisor in CGV's Disability Rights Office, will present the item.
Thank you, and good morning, Madam Chairwoman and Commissioners. I am pleased to present this draft notice of proposed rulemaking and order on VRS compensation. If adopted, this item would seek comment on compensation from the TRS fund for the provision of VRS after the current compensation plan expires June 30th, 2021. The provision of VRS is entirely supported through the TRS fund. The notice proposes to continue using a tiered compensation structure, which the Commission has used since 2007 to compensate VRS providers. Under a tiered structure, the first set of monthly minutes for each provider is compensated at a particular level, the next set of minutes at a lower level, and so on, with the last tier having the lowest compensation level for all minutes above a certain number. By retaining this approach, the Commission would maintain the ability to preserve and promote quality of service competition among multiple providers and to bring TRS fund payments into closer alignment with allowable VRS costs. The notice seeks comment on whether to adjust the tiered compensation levels at this time to bring compensation closer to allowable costs, or to defer any compensation changes for 2 years to await the resolution of uncertainty about post-COVID-19 pandemic changes in VRS costs and demand. The notice also seeks comment on possible changes to the sizes of the current tiers, the level of the per minute compensation for each tier, and the duration of the next compensation period. The accompanying order extends the current VRS compensation plan through December 31st, 2021, or the effective date of the new compensation plan adopted pursuant to the notice, whichever is earlier. This extension ensures the Commission has sufficient time to complete its rulemaking without disruption to the provision of VRS. The Bureau recommends adoption of this item and requests editorial privileges for technical or conforming edits. Thank you.
Thank you. We will now hear comments from the bench. Commissioner Carr.
Well, I want to thank the CGB team for all their hard work on this important item. I think looking forward to getting it out there and moving forward on this issue. Thanks so much to the team for your work.
Commissioner Starks.
Yes, thank you, Madam Chairwoman. For an agency, it is typically good governance to develop more of a record than less. And in that way, the additional questions sought by VRS industry participants add important context to this discussion. I believe this will ultimately lead to an improved functional equivalence and service quality that will benefit those who need VRS to communicate and function seamlessly in our society. It's also prudent to extend the current rates while we gather more data and insight on what service levels look like on the other side of the COVID pandemic. And so I'm pleased to support this item. Thank you to the staff for their hard work.
Commissioner Symington.
Thank you. The pandemic has taught us many lessons, one of which is the importance of connection. Many Americans in the deaf and hard of hearing communities rely on ASL video relay services as a critical means to maintain the connections that matter most to them. From a call to grandma, to a consultation with a pastor, to just a status update at work. Video relay services provide a foundation for communication that is more important than ever in a distanced world. That is why it is vital that the Commission craft sensible policy to sustain a vibrant marketplace for providers, while at the same time encouraging them to provide better service offerings that draw nearer to the goal of functional equivalence that is at the heart of VRS. A temporary freeze in the compensation scheme should allow the Commission and providers the time they need to consider how best to achieve these goals. I would like to thank the staff and the Consumer and Government Affairs Bureau, who worked so hard to incorporate the thoughtful suggestions submitted by industry, together with my colleagues on the Commission and their staffs, who collaborated to produce a thoughtful and comprehensive item.
Thank you, commissioners. Under the Americans with Disabilities Act, functional equivalency is the foundation of our telecommunications relay service policies. Of course, functional equivalency may sound like lingo only a lawyer could love. But for millions of Americans, it means they have the ability to reach out, connect, and participate more fully in the world. And for those who are deaf and hard of hearing, having access to functionally equivalent services means having access to video relay service, or VRS. Now, the way VRS works is simple. A person using sign language signs over a video call to a specially trained communications assistant. The communications assistant interprets the sign language and relays it to the person on the other end of the call. And when the caller speaks, the communications assistant signs the response back to the person using sign language. If the service is relatively straightforward, the compensation system that supports it is anything but. The companies providing this service are paid by the Telecommunications Relay Services Fund, administered by the FCC. And for years, the agency has tried to set rates that permit providers of VRS to cover their costs while also promoting consumer choice and competition. The result is a three-tiered system that compensates providers based on their monthly volumes of VRS traffic. Now, it's been more than 4 years since the FCC last considered compensation policy for VRS. And since that time, there have been changes in technology and the marketplace, not to mention a global pandemic that has challenged our assumptions and projections about who will use this service and just how often. So it's the right time to refresh our thinking, and that's what this effort is about today. We ask what the compensation system should look like going forward and what needs changing. We ask if our current tiers get it right or if they should be adjusted. For example, we seek comment on updating the current rates and ask questions about whether or not our existing volumetric breakpoints used to differentiate rate tiers continue to make sense. On top of this, we ask if in light of the pandemic, it even makes sense to make big changes to our cost structure right now. Finally, to give commenters plenty of time to provide their thoughts and ideas, we've decided to extend the current compensation system through the end of this year. A special thank you to the Disabilities Rights Office for their commitment to functional equivalency and to all the staff responsible for today's effort. And from the Consumer and Governmental Affairs Bureau, that's Bob Aldrich, Diane Burstein, Elliot Greenwald, Kelly Preacher, Michael Scott, Bill Wallace, and Patrick Weber. From the Office of Economics and Analytics, that's Susan Lee, Virginia Metallo, Eric Ralph, and Emily Talaga. From the Office of General Counsel, that's Terry Kavanaugh, Richard Mallon, and Bill Richardson. And from the Office of Managing Director, that's Andrew Mullins and Dave Schmidt. We will now proceed to a vote on the item. Commissioner Carr.
Approve.
Commissioner Starks.
Approve.
Commissioner Symington.
Approve.
And the chair votes aye. The item is adopted with editorial privileges as requested. So, Madam Secretary, please announce the next item on today's agenda.
Madam Chairwoman and Commissioners, item 3 on your agenda is entitled Call Authentication Trust Anchor and will be presented by the Wireline Competition Bureau and Chris Monteith. Chief of the Bureau will give the introduction.
Thank you, Madam Secretary. Ms. Monteith, please proceed.
Thank you. Madam Chairwoman and Commissioners, the Wireline Competition Bureau presents for your consideration a third further notice of proposed rulemaking on caller ID authentication. This item, if adopted, would propose additional action to stem the tide of illegal robocalls by accelerating the date by which small voice service providers most likely to be the source of illegal robocalls must implement the stir-shaken caller ID authentication framework. I would like to thank the Bureau team for their hard work on this item, as well as our colleagues in the Consumer and Governmental Affairs, International Public Safety and Homeland Security, and Wireless Telecommunications Bureaus, and the Offices of Economics and Analytics and General Counsel for their review and helpful input. Jonathan Lecter, an attorney advisor in the Wireline Competition Bureau's Competition Policy Division, will now present the item. Jonathan?
Thank you, Chris. Good morning, Madam Chairwoman and Commissioners. Each day, Americans receive millions of unwanted phone calls. These include spoofed calls, where the caller falsifies the caller ID information that appears on a recipient's phone to deceive them into thinking that the call is from someone they know or can trust. Implementation of caller ID authentication technology, specifically the framework known as stir-shaking, will reduce the effectiveness of illegal spoofing, allow law enforcement to identify bad actors more easily, and help voice service providers identify calls with illegally spoofed caller ID information before those calls reach their subscribers. The Commission required most voice service providers to implement this technology in their Internet Protocol networks by June 30th, 2021. It granted some providers additional time to implement stir-shaking, notably small voice service providers with 100,000 or fewer subscriber lines have until June 30th, 2023. New evidence suggests, however, that a subset of small voice service providers is originating a large and increasing quantity of illegal robocalls. If adopted, this third further notice of proposed rulemaking would first propose to shorten the extension for this subset of small voice service providers by 1 year and require these providers to implement stir-shaking in the Internet Protocol portions of their networks no later than June 30th, 2022. Second, it would comment on how best to identify and define those small voice service providers at a heightened risk of originating an especially large amount of illegal robocall traffic. Third, it would comment on whether to adopt additional measures to facilitate oversight and ensure that small voice service providers, subject to a shortened extension, implement stir-shaking in a timely manner. And finally, it would comment on the Commission's authority under the TRACE Act to modify the existing extension. The Bureau recommends adoption of this item and requests editorial privileges. Thank you.
Thank you. We will now hear comments from the bench. Commissioner Carr.
Thank you so much again for the team for all of the hard work on this item. I appreciate it and I support our vote today.
Commissioner Starks.
Yes, thank you. After a brief slowdown early last year that many attribute to the impact of the COVID-19 pandemic on mass calling operations, multiple reports indicate that robocalls are on the rise again sharply. Once or measured a record number 6.3 billion spam calls in March of 2021, surpassing the previous month's total of 5.6 billion and the prior monthly high from October of 2020 of 6.1 billion. And so clearly, we cannot afford to let up on our efforts to identify the culprits of these annoying and frequently fraudulent calls. And so I support seeking comment to determine whether we should require certain small voice service providers known to be generating a disproportionately large number of these illegal robocalls to implement the stir, shake, and caller authentication framework a year ahead of schedule. Consumers deserve protection from unwanted and illegal robocalls. And so I'll continue to support this and any additional items to identify and stop those responsible for placing them. Thank you.
Thank you. Commissioner Sinington.
Thank you. I'd like to I'd like to thank the staff for their hard work on this item, and it has my support.
It's a fact that during the last several years, the number of robocalls skyrocketed. It's also a fact that we need to do more to stop these annoying and abusive calls. The good news is that today's rulemaking seeks to do just that. It speeds the way for the deployment of caller authentication systems known as Stir Shaken. When Stir Shaken is in place, carriers can verify that callers are who they say they are. It can help stop spoofing and the scams that it can foster. And it's why the FCC has required carriers to implement Stir Shaken in the IP portions of their networks by June 30th of 2021. However, smaller carriers with fewer than 100,000 subscribers were given additional time to implement Stir Shaken. That makes sense for honest providers who have fewer resources to come into compliance. But we recently discovered that some of these smaller companies are pumping large volumes of traffic onto our networks, and a lot of it looks suspiciously like robocalls. So it's time to change course. And here we propose to cut back on the extension for smaller providers that are sending these junk calls. Now, implementing Stir Shaken and doing it faster, as we propose here, will help reduce robocalls over time, but we need to do a whole lot more. That's why we just issued a $225 million fine, the largest in the agency's history, to Texas telemarketers for illegally spoofing more than 1 million robocalls. That's why we have sent 3 sets of cease and desist letters to 10 different providers that appear to be facilitating illegal robocalls. These letters are a final warning, because if they don't act within 48 hours, we authorize all other providers to block their traffic. That's why we mandated that all carriers register themselves in a robocall mitigation database and tell us what they're doing to stop illegal robocalls. And failure to register has consequences. We will tell all other providers to block their traffic. That's why we've set up a robocall response team here at the FCC with over 50 attorneys, economists, engineers, and analysts from 4 bureaus and 2 offices. The team is reviewing our rules, policies, and practices to identify and close gaps that allow illegal robocalls to continue. That's why we've written to all major carriers to survey free robocall blocking tools they make available to consumers. We've written developers too. And what we learn in response will inform a robocall blocking report we will issue this summer. That's why we set up a website where the public can track our implementation of the TRACED Act, the most recent legislative effort to stop robocalls. But we're not stopping there, because we're looking for holes in all existing laws and will support the development of new ones to prevent these annoying calls from coming through. And that's why we've redoubled our efforts to work with the Department of Justice, Federal Trade Commission, and National Association of State Attorneys General to crack down on robocalls, because we want to see actions taken and fines collected across all of our jurisdictions. And we're just getting started. So I'd like to thank the staff who worked on this rulemaking, including Pam Arlick, Michelle Burlove, Matthew Collins, Lynn Engeldow, Justin Fall, Victoria Goldberg, Alexander Hobbs, Dan Kahn, Jonathan Lecter, Albert Lewis, Chris Monteith, and Gil Strobel of the Wireline Competition Bureau, Jerusha Burnett, Aaron Garza, Kurt Schroeder, Mark Stone, and Christy Thornton of the Consumer and Governmental Affairs Bureau, Kim Cook and Jim Schlichting of the International Bureau, Ken Carlberg of the Public Safety and Homeland Security Bureau, Eugene Kiselev, Julia McHenry, Chuck Meady, Eric Ralph, and Emily Talaga of the Office of Economics and Analytics, and Michelle Ellison, Richard Mallon, Linda Oliver, William Richardson, and Derek Yeo of the Office of General Counsel. We will proceed to a vote on the item. Commissioner Carr.
Approve.
Commissioner Starks.
Approve.
Commissioner Symington.
Approved.
The chair votes aye. The item is adopted with editorial privileges as requested. Madam Secretary, please announce the next item on today's agenda.
Madam Chairwoman and Commissioners, the fourth item today, entitled Domestic Section 214 Application for Transfer of Control of Lavaca Telephone Company, Inc. to Dobson Technologies, Inc., will also be presented by the Wireline Competition Bureau. And once again, Chief of the Bureau, Chris Monteith, will give the introduction.
Thank you, Madam Secretary. Ms. Monteith, please proceed.
Thank you, Madam Chairwoman. Today, we're pleased to present for your consideration an order on reconsideration that would, if adopted, grant a petition for partial reconsideration to relieve certain merging companies and their affiliates that receive high-cost universal support through different types of fixed and cost-based support mechanisms from having to comply with the mixed USF support merger condition. I would like to thank, as always, the Bureau team for their hard work, as well as our colleagues of the Office of General Counsel for their helpful input. Presenting the item today from the Wireline Competition Bureau's Competition Policy Division is Dennis Johnson, Attorney Advisor. Dennis will now present the item.
Good morning, Madam Chairwoman and Commissioners. The Commission refers to Section 214, Transfer of Control Transactions, involving merging companies that receive high-cost universal service support under different support mechanisms as mixed support transactions. And it's found that these transactions raise potential public interest concerns. A company receiving a fixed level of USF support acquires or is acquired by a company receiving cost-based USF support. Combined companies could have an incentive to shift shared or common costs from the fixed model-based support company to the cost-based company. As a result, the combined post-transaction company could receive additional universal service support because of accounting procedures rather than increased investment or expenses that would benefit customers. This mitigates this potential cost shifting by conditioning mixed support transactions on the post-transaction company being subject to a high-cost universal service support cap. This mixed USF support merger condition caps the combined operating expenses of post-consummation companies' cost-based support rated return affiliates. The order on reconsideration will grant a petition for partial reconsideration and modify the mixed USF support merger condition that the Bureau applied to its approval of the transfer of control of the Lavaca Telephone Company, the incumbent local exchange carrier, received cost-based universal service support. The Dobson Technologies, a company that owns an incumbent local exchange carrier that receives fixed amount of universal service support under the Alternative Connect America model. Dobson also holds an indirect, non-controlling minority interest in Fort Mojave Telecommunications, an incumbent local exchange carrier serving the Fort Mojave Indian tribe in Arizona, California, and Nevada that receives cost-based universal service support. The order would find that the potential cost-shifting harm that the fixed USF support merger condition is designed to address is not present with Dobson affiliate. Mojave because companies do not share any common costs, maintain separate books and accounts. Dobson has no controlling interest in Fort Mojave in any capacity. It would also reaffirm the Commission's delegation of authority to the Bureau to apply the mixed USF support merger condition where necessary to remedy the potential public interest harm, including the only certain affiliates in a mixed support transaction. The Bureau recommends adoption of this item and requests editorial privileges extending only to technical and conforming edits.
Thank you. We will now hear any comments from the bench. Commissioner Carr.
Thank you so much to the team for your work on this recon order. It sounds like we might need to get you some stronger, more robust and resilient internet connectivity to up the audio quality there. But thank you again for all the work on the item. Thanks.
Commissioner Starks.
Commissioner Carr. A brief comments from me. Thank you so much. When it considers transfers of control of lines or authorizations to operate pursuant to Section 214 of the Communications Act, the Commission has an important responsibility to protect the Universal Service Fund. The order on reconsideration we adopt today carefully delineates the circumstances where one of our tools for protecting the fund, the mixed support condition, is not necessary. And so I'm pleased to approve that decision, reaffirm our delegation of authority to the Wireline Competition Bureau to continue applying the mixed support condition in appropriate cases. Americans have quite reasonably high expectations for the expanded broadband access that the Commission will support for billions of dollars over the coming years. And so going forward, we must continue to carefully evaluate any proposed transactions that come before the Commission to ensure that both USF funding will be used effectively and efficiently, and that the parties who take on USF obligations have the required technical and financial capabilities to perform. Thank you to the staff for their hard work on this item and their ongoing work safeguarding the Universal Service Fund.
Thank you. Commissioner Symington.
Thank you. I concur with my fellow commissioners' remarks, and I'd also like to thank the staff for their work, and this item has my support.
Thank you, commissioners. Look, there's no shortage of complex issues that come before the FCC, but mixed support mergers between telecommunications carriers may be among the most obscure of the complex issues that the agency is called upon to address. So let me try to explain why they are important. Rural telephone carriers that rely on our universal service system to keep their communities connected can receive support in one of two ways. Some receive support based on our traditional methodology, which is based on their costs. Others have elected to receive their support based on a model that provides a fixed amount. So when a cost-based company combines with a model-based company, we have a regulatory wrinkle. The combined entity will have an incentive to shift costs to the cost-based company in order to receive more support. And to iron this accounting situation out, we have required that when these mixed support transactions take place, the expenses of the cost-based affiliates are capped based on average expenses from the last 3 years. And this prevents cost shifting. Here, when Dobson, a model-based company, and Lavaca, a cost-based company, sought to combine, the Wireline Competition Bureau imposed this mixed support condition on the transaction. No one disputes that this was correct. However, Fort Mojave Telephone, a cost-based carrier serving the Fort Mojave Indian tribe, is also subject to this condition because Dobson holds an indirect interest in Fort Mojave Telephone. But the parties have now shown that Dobson exercises no control over Fort Mojave Telephone, which is majority owned by the Fort Mojave Indian tribe. That means there's no danger of cost shifting to Fort Mojave. In fact, Fort Mojave's tribal broadband development plans could be hindered by the mixed support condition. So today we exempt Fort Mojave Telephone from the mixed support condition and lay out a framework for the Bureau to do the same and other transactions in the future where the facts support it. So like I said at the start, this is complex. But going forward, we will fine-tune our policy so it will not get in the way of deployment in rural areas and tribal lands. So a hefty thank you to Pam Arlick, Justin Paul, Dennis Johnson, Jody May, Sue McNeil, Chris Monteith, Terry Natoli, Ryan Palmer, Joe Cereso, and Suzanne Yellen of the Wireline Competition Bureau, and Melina Barzilai, Jim Bird, Bill Dever, Michelle Ellison, Richard Mallon, Linda Oliver, Joel Rabinowitz, and Bill Richardson of the Office of General Counsel. And with that, we will now proceed to a vote on the item. Commissioner Carr.
Approve.
Commissioner Starks.
Approve.
Commissioner Symington. Approved. And the chair votes aye. The item is adopted with editorial privileges as requested. Madam Secretary, please announce the next item on today's agenda.
Madam Chairwoman and Commissioners, item 5 and item 6 on your agenda are enforcement matters for your consideration. The items will be presented by the Enforcement Bureau, and Rosemary Harold, Chief of the Bureau, will give the introductions.
Thank you, Madam Secretary. Because these orders involve enforcement-related matters, we're going to switch the order up slightly, as the Commission has done in the past cases that involve the presentation of a forfeiture order at an open meeting. As with all open meeting items, the Bureau circulated these items to every commissioner at least 3 weeks ago. But there is a long-standing practice at the agency that we do not publicly disclose the target of an enforcement action unless and until the Commission decides to take that action. For these items, this means that the agency formally votes on the items, then hears a brief presentation from the Bureau before proceeding to any statements that the commissioners may have. This process ensures that the targets of our decisions will not be publicly disclosed until the FCC has voted to take action. We are following that precedent here. So we will now proceed directly to vote on the items. For item number 5 on the agenda, Commissioner Carr.
Approve.
Commissioner Starks.
Approve.
Commissioner Symington. Approved. Chair votes aye. The item is adopted with editorial privileges as requested. If requested. Item 6 on the agenda, Commissioner Carr.
Approve.
Commissioner Starks.
Approve.
Commissioner Symington. Approved. And the chair votes aye. The item is adopted with editorial privileges if requested. Ms. Harold, please proceed with introducing item number 5 and item number 6 on today's agenda, which will be presented jointly.
Thank you, Madam Chairwoman and Commissioners. And also thank you for your consideration and your votes on today's items. 2 forfeiture orders against Airtel LLC and IOU Acquisitions Inc. Presenting with me is Mark DeSantis. I would also like to thank Chris Killian, Deputy Bureau Chief, Jeremy Marcus, Associate Bureau Chief, and Ashley Tyson, the legal advisor to the EB front office, as well as Elizabeth Mumont, Chief of the Spectrum Enforcement Division, Joanne Lukanik, Deputy Division Chief, and Jason Kozlowski, Assistant Division Chief, for their work on this investigation. The Bureau also thanks the Office of General Counsel, the Wireless Telecommunications Bureau, and the Office of Engineering and Technology for their invaluable support. Mark will now present the item.
Thank you, Rosemary. Good morning, Madam Chairwoman and Commissioners. These forfeiture orders find that Airtel LLC and IOU Acquisitions Inc. provided unlicensed wireless broadband services under the guise of providing radio location service and provided those services using unauthorized equipment. Such actions, if left unchecked, could create harmful interference to other wireless services whose providers abide by their license terms and also give the violators an unfair competitive advantage in the marketplace. The Enforcement Bureau's investigation into Airtel and IOU was prompted by a complaint filed with the Commission alleging that the companies were providing wireless data transmission service rather than radio location service authorized on the company's licenses. Radio location service is typically a radar-based service in which licensees rely on the propagation properties of radio waves to determine the position of an object. In contrast, wireless data transmission service is a service in which data is transmitted and embedded within a wireless signal. These are technologically distinct services, each requiring different types of equipment and typically employed for very different purposes. Other radio location licensees have used their licenses for perimeter security and weather radar, while wireless data transmission, as employed by IOU and Airtel, included internet, voice, and web access. By flouting the terms of their licenses, Airtel and IOU disregarded the government's most basic and time-honored tool for fostering a lively, competitive market for all wireless services, the Commission's licensing system. First devised nearly 100 years ago, that system is designed to minimize harmful interference to radio communications and ensure a level playing field among competing wireless service providers. While the FCC today encourages innovation in the wireless services, that does not mean that a company may, all on its own accord, use a commission license that authorizes the provision of one type of service to provide a wholly different, unauthorized service by altering equipment for non-compliant uses. Here, our investigation showed that Airtel and IOU did just that. Over the course of several years, the two companies each sold and operated a GPS vehicle tracking service that was neither authorized under their radio location service license in the 3300 to 3650 megahertz band, nor permitted under the service rules for that band. They also unlawfully modified equipment to operate the unauthorized service. The Commission issued a notice of apparent liability for forfeiture that proposed a monetary forfeiture against each company for its unauthorized service and unauthorized equipment. The companies responded, and now, after fully considering those responses, we affirm all the findings in that notice. Accordingly, today's forfeiture orders impose a penalty of $327,290 against Airtel and a penalty of $207,290 against IOU Acquisitions. For these reasons and the additional detail laid out in the forfeiture orders, the Enforcement Bureau appreciates the Commission's adoption of these items and the grant of editorial privileges. Thank you.
Thank you. We will now hear any comments from the bench. Commissioner Carr?
Thank you to the Enforcement Bureau team on this one. It has my support.
Commissioner Starks?
Yes, nothing additional from me either. Thank you for the hard work enforcing our rules on this one. Thank you.
Commissioner Symington?
Thank you. No additional comments and greatly appreciate it.
Thank you, commissioners. You know, it doesn't get much airtime, but one of the most important part of this agency's work on spectrum policy is enforcement. After all, the most dynamic, innovative, and data-driven spectrum policy doesn't amount to much if licensees don't feel compelled to comply with our rules. That's why we take the action we do today. These cases involve two operators licensed to provide radio location, a service that uses radio waves to identify objects using the 3.3 to 3.65 gigahertz band. But instead, they offered a different navigation service and modified their equipment in ways that were not authorized under our rules. As a result, they increased the likelihood of interference to other licensees using the band and following the rules. This failure to honor our policies has a cost, and that leads us to the forfeiture decision here. In addition, resolving these matters clears the way for the agency's upcoming efforts to introduce new 5G uses in these airwaves. So thank you to the Enforcement Bureau for bringing these cases before us, including Mark DeSantis, Rosemary Harold, Christopher Killian, Jason Kozlowski, Shannon Lip, Joanne Lukanik, Jeremy Marcus, Elizabeth Muma, and Ashley Tyson. Thank you also to Jess Grafinius, Joyce Jones, and Paul Powell from the Wireless Telecommunications Bureau, David Horowitz, Douglas Klein, Linda Oliver, and William Richardson from the Office of General Counsel, Ira Keltz and Tom Struble from the Office of Engineering and Technology, and Virginia Metallo from the Office of Economics and Analytics. All right, getting through things in record time today. Would any of my colleagues like to make any announcements at this time? We'll start with Commissioner Carr.
Nothing from me. Thank you.
Commissioner Starks.
Nothing from me either. Thank you, Madam Chair.
Oh my gosh, moving right along. Commissioner Symington.
Thank you, Madam Chairwoman. No additional remarks.
All right. Well, you're not so lucky because before we adjourn, I'd like to make a few brief announcements, and these are important. First, I want to acknowledge that the FCC's own legendary Evan Burrow has been named a finalist for the 2021 Samuel J. Heyman Service to America medals. Those are known as the Sammys. And they are the Oscars for federal government employees. Evan is a finalist in the Paul Volcker Career Achievement Award category, which recognizes federal employees who have led significant and sustained achievements in positions of government services for 20 or more years. Now, a lot of people at the FCC know Evan Corll as the godfather of spectrum auctions, and appropriately so. He started his FCC service in 1983 as a senior economic advisor and immediately began laying the groundwork and crafting the framework for the FCC's first spectrum auctions in 1994. Evan quite literally wrote the book on spectrum auctions. And last year, when Paul Milgram and Bob Wilson won the Nobel Prize for their work in economics, the FCC's innovative and efficient use of spectrum auctions were noted. Paul Milgram wrote that Evan's individual contributions were so major that it would have been appropriate for him to share this prize. Again, that's the Nobel Prize. The FCC cannot thank Evan enough for his multiple decades of public service, and I can't think of a better nomination for a Sammy. Congratulations and good luck, Evan. Next, on a slightly different note, I want to recognize another titan in our auctions world. Margie Wiener will be retiring at the end of the month after nearly 24 years at the commission. She joined the agency in 1997 as a staff attorney in the Auctions and Industry Analysis Division. Because of her hard work and keen mind and the support she gave her colleagues, she quickly became branch chief and then deputy division chief. And in 2000, Margie became division chief, serving in that role for over 19 years. During that time, she oversaw over 2/3 of the commission's auctions, guiding the program through one major accomplishment after another. To name just a few, Margie led the team that drafted FCC policy rules and procedures for a little novel two-sided incentive auction known as the Broadcast Incentive Auction. She contributed to the development of policies, rules, and procedures for the team that conducted the first FCC auction to distribute universal service support. And she established and fostered cross-bureau coordination and communications that ensured the success of some of our other most complex auctions, including the second incentive auction for the upper 37, 39, and 47 gigahertz bands. She also led the division through the reorganization that established the Office of Economics and Analytics, where she joined the office as a deputy division chief in 2020. Margie is a past recipient of the FCC's Gold Medal for Distinguished Career Service. Her team describes her not as a boss, but as a leader they're simply lucky to have. She's left an indelible mark here at the agency, and her diligence, dedication, and service have had lasting impact. We wish her only good things in retirement. So now, if my colleagues don't have any further announcements, Madam Secretary, please announce the date of the next FCC agenda meeting.
The next agenda meeting of the Federal Communications Commission is Thursday, June 17th, 2021.
Until then, we stand adjourned.